We have Ms. Tucker. Tucker, who's appearing via Zoom.
Thank you, Your Honor. May I be excused?
Yes, thank you.
Thank you.
So, there's an update in this case is the third came back and denied the writ. So, Mr. Tucker, you're still representing yourself? Thank you. Good morning.
Good morning. Yes, sir. I'm not sure if you can hear me.
Yes, I can.
Okay.
Judge, if I may just jump in here on behalf of the state, we have a negotiated plea worked out in theory. We're still trying to work out some of the logistics. I did reach out to your judicial assistant, Ms. Corrali. She did provide some available dates. I know that Mr. Mansfield asked me to request the 26th at 4 o'clock. We intend on drafting a plea agreement and going back out to the jail to review that with Mr. Tucker in person and make sure it's signed before that date, so that when we come in on the 26th, everything is nice and smooth.
Okay, the time there would be 4 p.m. a special set hearing after the regular next felony docket signing.
Yes, sir. It was she gave November 26th at 4 p.m. Yes, sir.
Okay, great. So right now, just for your planning purposes, we only have 13 cases on that day at 1:30. That's okay. The public defender's docket, so that there may be a good, 10 or 15 cases added on, but we should have plenty of time. So let me know if, based on whatever the particulars are, if you think it's going to take an extra 30 minutes. We could potentially try to do a 3:30 p.m. start time.
Okay. Well, that's not a problem, Judge. Mr. Mansfield and I will show up at 3:30 and just be on standby.
Yeah. Do you expect that we could get that done in 30, 45 minutes, an hour?
Yes, sir, I do.
Okay. Mr. Tucker, anything that you wanted to add, sir?
No, that was my understanding as well. I thought we were going to get it done a little bit sooner, but that's okay. It's fine.
Okay. Well, you see, maybe we could, but I have a trial week. I have a whole week set aside next week, Mr. Tucker. So next week, there's, with the exception of Thursday morning, where I have a few cases. I don't have anything scheduled, but I'm not going to know for sure until tomorrow by lunch. Tomorrow by lunch, I'm going to know whether I have 1, 2, or 3 cases set for trial next week. In the event there are no cases set for trial next week, then that opens up essentially 4 full days. So Mr. Alvarez could even reach back out, and if it works out for you and for his office, I mean, we could do it, on the 19th or the 20th or even the 22nd. Or even the 20th in the afternoon.
That sounds good to me, Your Honor. Just, obviously my schedule is what I know. So, it's up to Mr. Alvarez and Mr. Mansfield at that point.
Judge, I'll circle back with Ms. Corrali tomorrow afternoon after 12 just to see if there's any availability.
Thank you.
Thank you.
Stay in contact with my office.
Thank you, Judge.
Thank you, Your Honor.
We're going to put it on for the 26th for now. I want it to be put somewhere, and then.
All right, welcome, guys. What you just saw there was a hearing that took place. I guess what was it? A couple days ago, last Friday, I believe it was, if I'm not mistaken. If my memory serves me correct. So. What you just saw there is, it appears Ty is working on, and my sources tell me he is working on negotiating some sort of plea. Now, I don't know the details of it. All I know is it's not going to be pleading to anything that, again, I don't know the specifics, but I believe it's probably going to be some form of an Alford plea, which is what he had been offered previously, meaning he doesn't have to admit that he's guilty, but that they're going to enter the plea, and then it's going to essentially amount to him getting out of jail and not having to serve any probation, not having to do anything else beyond show up in court on the 26th, and then he's free of these charges.
So the Alfred plea is a plea of, it's a plea of not guilty or guilty, but Is it not guilty?
Well,
But he recognized.
as far as the court record's concerned, whatever the Alford plea is taken to, he's guilty. But what it does is it allows him. Normally, when you plead guilty, you're forced to go before the judge and give a layout of the crime you did. So you're forced to say, "This is how I did it. This is what I did." Da 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 da. Instead, he's going to get to actually go. Yes, well, it's similar to it, Sidney Braddock, but normally in a no contest plea, he remains silent and he just says he's still considered to be factually guilty. He's just saying there's an overwhelming amount of evidence, and I'm not pleading guilty, but I'm just saying there's enough evidence to convict me. In this, it goes a step further. He still pleads guilty, but he actually gets to go on the record and as part of the court record, he gets to say, I'm innocent, and this is why I'm innocent. So he's actually going to get the opportunity to put as part of the record, I'm innocent, I'm not guilty, but I feel like I have no resources to fight. They've given me this opportunity to get out of jail. And in this case, we can kind of understand why, because he's trying to go pro se. He has no money left. He's got no resources to fight. And right now, as you all know, or should know, as you probably heard at the beginning of that, the third DCA appeal was rejected. He didn't respond to it. Of course, there's a lot of problems with when you're pro se and not out on bond because there's delays, but he only had 10 days to respond to the Attorney General. He missed that deadline. Third DCA kicked it out and denied it. So as a result, he had to hold on.
Plan B.
Yep.
But the Alfred plea has a sentencing component to it, so that would mean that he agrees to the time served and can.
Well, he's sentenced. Yeah, on an Alfred plea, he's subject to whatever sentence it would be.
So the judge can still say, no, you need to spend another 12 months.
Correct.
Or whatever.
Yep. Thank you, Flash Fan. Appreciate you.
Hey, Flash Fan.
Well, yes, exactly. He basically, the bottom line is this, is the judge, when they do an Alfred plea, typically, you don't do it. A no contest plea is where you might plead no contest. The sentence is left wide open. The judge still sentences you based on whatever, there's still potential he could get 20 years. Alfred pleas are worked in the way that they're going to already have the outcome worked out. So
that's all what they're negotiating now is the details of, whether or not time served is enough and all that sort of stuff. Yeah.
Correct. Yep. Now, all right. So Nicole said, "Yeah, I highly doubt he missed the date for turning in
snail mail."
Yeah. Well, it's not even that. It's that I don't even think he got notified of the state attorney general's response, but he still has 10 days, and they don't hold that up based on everything. So he would have to go through an arduous process of proving that he didn't get it, he didn't have timely amount, and they would maybe let him do it. But the bottom line is, it's a issue of it just for him as a pro se defendant. He's got a judge that doesn't like him. He's got a lot of things he's fighting, and he's sitting in jail the whole time, and that's not a fun place to be, especially not Monroe County.
He looks really pale. You just went mute. You just muted.
No, I know. I'm talking to myself.
No.
Behind me and he can turn his iPad up and he's singing now really loud. So
how did these discussions commence? How did they start? Were they a little bit shady?
As far as what the
discussions
for the plea deal, well, my sources tell me that he was taken out in the middle of the night. But I don't know anything specific firsthand, so I don't want to get too deep into that rabbit hole. But my sources tell me he was pulled out at nighttime to begin this discussion process. But again, Christine Fortunato says he's going to be in jail for good. Who's going to be in jail for good? Christine Fortunato. What are you talking about?
Yes, Florida is crooked.
Yeah.
Absolutely.
So, oh yeah, it absolutely is.
So he will then have a conviction if this all goes down as planned.
As
he will still have
on whatever it is he took a plea to.
Mm-hmm.
What do you mean, Christine? I don't understand what you mean by that. He's going to be in jail for good. That doesn't make any sense. If he works out whatever he works out, he's not going to be. I mean, the point of an Alford plea is he gets to say, and this is the benefit of it from a record standpoint. He's whatever he's pled to. So they don't even he's charged with several things. They could charge him with, they could charge him with jaywalking. They could charge him with, some other thing that he might have done, and that's how they choose to work the case out.
Yeah.
But he's going to get to go. But let's just say they said, okay, you got to plead to robbery in this. Well, the state's going to get the benefit of saying, okay, there is a guilty, as far as if a background check was done and everything, it'll be there. But the record will state that it's an Alford plea, which means somebody would go pull the record, the transcript, and he's going to be able to say, hey, this is what, when he makes his record, he gets to make his record of innocence.
Good.
So it's like one of those opportunities where you have on your credit bureau and you dispute something and they don't take it off, but they say you can put an explanation on it.
Yep.
So it's still a negative. It's still negative. It still affects you. It still affects your future. But there's something there that says this shouldn't be on here. And it just gives a little bit more credibility when you're talking to people saying, this is a set of circumstances I was faced with. I couldn't fight back. I didn't have the resources to fight back.
Hey, it beats a murder conviction.
Well, absolutely, because...
And an incorrect one at that.
Well, I mean, listen, okay, the thing that people have to understand is what they did to him in that first trial was extremely dirty.
Mm-hmm.
He got to place to live when he got out. When he get out, what are you talking about, Christine? I don't know what you mean.
Has he still got his place in Oregon?
I have no idea. I don't know. I have no idea on that. I don't believe so, because I think obviously I don't think anybody would be keeping that around it when he's you'd have to be paying rent on it. So my assumption would be that no, probably not. But he's I think I know he has his brother and everything. I'm sure he's got a plan. That I don't know. I have no idea what that plan would be, but I'm sure there will be a plan. There will be something going down. He's got things that he's working on that, listen, he's going to be able to get out and talk to the public about this. He's going to be able to go around and discuss his situation. He's going to still be, I do believe the Alford plea still allows him, it will still allow him to go after them. Civilly, correct, yes. Because it's recognized that he's not admitting. That's another benefit of the Alford plea is it is recognized that it doesn't take away his ability to go after them because it's not a guilty plea. He's not admitting. In other words,
so they're not
normally when you plead guilty.
Prosecutorial misconduct, is that it?
Yep. It would. What's that now?
So they're not then immune to the prosecutorial misconduct.
Well, meaning normally if he would plead guilty, it would just be taken. He'd be prevented because it would be a matter of fact that he's admitting to these things he did. It's not a matter of fact. It's still got to be proven. Now he's still got to prove his case, but they don't get to just go in and say it gets dismissed because Ty Tucker took a plea guilty or took a guilty plea. He took an Alford plea. So a court would recognize that is not an automatic admission of guilt because he didn't admit to guilt. So they would still civilly have to defend and say, well, we got to go to the court. So he still gets the ability to do all of that. So like I said, he's going to have a big interest in fighting back. This doesn't end the fight, right? This just begins the fight. And once we see whatever it is he's working on, everyone will be able to understand it better. But I'm told that it's definitely not, he is not pleading guilty to anything that he
He
did
would
here.
never.
No
way.
so he's definitely not doing that.
I actually think this is probably one of the best case
Well, it's what
scenarios
I
for
told him
him.
he should have done. Listen, when he got done with that mistrial, he was offered an Alfred plea, and he did. Now he was out, right? He was out on bond, and I understand to a degree why he wanted to fight, but he said, "No, I'm not doing it at that point." But now that he's in jail, sitting in jail, I mean, this thing could drag on. If he continues to try to fight this, he tries to get a new. Listen, he's sitting in jail that entire time. He's basically serving a sentence. And jail is not a cakewalk. Jail is, there is a reason why they like to get people without bond. There's a reason why Diddy's sitting there without bond, because it is meant to get into your mind. It is meant to make you not want to be there. And in fact, many want to get to a prison because you get the ability to walk around. You get the ability to have a job. You get, like, prison is considered freedom compared to what you're sitting at in a county jail, because you're just in a pod. I mean, if you want to go watch jail. You'll see it. The TV show where people voluntarily get locked up. It's really bad on the mind, when you're sitting in that environment. And in Florida, it's not uncommon for someone to sit there 5, 6, 7, 8 years, waiting on a trial. Well, yeah, no question under your stars. I understand that, but I'm saying, as a matter of strategy, it was their strategy to get him into jail for two-pronged effect. One, to help people turn out against Diddy, and two, it makes him more willing to potentially take a plea down the road to say, I want to get the hell out of that Manhattan detention center.
Oh, I've no doubt, Nicole. No doubt.
Oh yeah, absolutely. It's a very corrupt system down there. Nicole Lee says, I hate to burst everyone's bubble, but it takes a lot to fully grasp exactly how crooked the system is. Oh, it's extremely crooked down there. I mean, listen, just a cursory view. This is what gets me. I don't understand how people are not, and I'm not talking about people in this chat. I'm talking about the people like for instance, now there's something we need to go in and do, Jody. It just came to my mind. And we need to do that. We need to address this situation. Give me one moment. Because someone finally took up Ty's case, and it is so incredibly offensive. I don't know if anyone saw it. It was on Law and Crime, and I don't know if you guys
took up. What do you mean, the creator?
Well, the judge. You remember? Does everyone remember the Parkland case? It was a school shooting. The Parkland school shooting.
I remember.
There's a judge in there. She became very famous, and Law and Crime decided to give her a show, and her inaugural show decided to be about stupid pro se defendants. And I cannot help but think, but a Florida judge decides to take this on and decides to go after Ty. It's pretty clear she doesn't look at the case, because she completely goes after the one thing Ty brought up to the third DCA, which was, and which he was asking all of us to go out and talk about. Remember, when we were asking to file complaints against the prosecutors? She goes, and the one thing she highlights is the issue with the knife. And she tries to portray this, that Ty is basically in the wrong, that he doesn't know what he's doing, that he's improperly giving a closing argument, that he shouldn't have. Well, you have to watch it. You understand. It's a total reconfiguring of this moment without any background. I cannot believe that this woman, this judge, would actually be watching this and have watched everything unfold, given that Vinnie Politan watched it all unfold and said this is unethical on the prosecutor's part. She tries to portray this as Ty's a stupid pro se defendant who is unfairly trying to make the prosecutors look corrupt. And I'm like, you got to be joking.
She sounds like Carpenter.
So I'm trying to find this here, because I wanted to bring it up because we need to react to it. And that's what we need to do to it and set it straight. So I think we're going to do our own show on it at some point. Because it is absolutely distasteful. Because she clearly doesn't know the case. So she either just, here it is. Judge reacts with Liz Schroyer. Here it is, right here. All right, let's go over here to the Ty Tucker case. So we're going to go, here it is, right there. So we'll switch this over. I'll get it shared up, and then this is just something that we got to take down because it's just not right. It really isn't. So let's go back over to where we were here. New scene. All right. And this is Judge Schurer. This is her first ever Judge Reacts with Judge Liz. And she decides.
So this is when Ty.
This is Judge Reacts to arrogant defendants representing themselves at trial. So this is how. Now she put some other ones in there. Like the guy that did the ran his car in at a parade and all that stuff. And let me add a layer here. Hold on a second. I want to.
So this is from the first trial where he's taken the stand in his own defense, yeah?
Well, sort of. She just chooses this as her intro clip. She kind of tries to take him apart, just completely take him apart. And it's just so wildly offensive the way she does this because it's just like not true. It is not. You see what she tries to do. But she attacks a specific part. And it's the part that Ty was trying to get people to go after the prosecutors for, because she was wanting. Essentially, it's the part where they were trying to portray the knife. Remember, and say that the knife was that the only way he could find out about the blood on the knife was through. Yeah. But she tries to portray this as, you can't have a statement come in during closing arguments because he probably asserted his rights. That's why it wasn't brought in. Well, that's not why it was brought in. It was brought in. It was not brought in because his statement was consistent with what he told the police, and you can't bring in a prior consistent statement. And then the state went and lied to the jury about that and tried to say that there was no other way for him to know there was blood on the knife when there was. It was because Penny Phelps told him. But this judge tries to portray this completely different, and it's just completely offensive. Give me a moment here. Let's go here to.
Hi, Jenny.
All right, so we're going to hit play here.
Back in November of 2017, Franklin Tyrone Tucker took part in a botched robbery that turned deadly. Tucker allegedly initiated the robbery when he found out that there was a large sum of money being kept in a treehouse located in an area known for high crime in the Florida Keys. Tucker had an advantage over Matthew Bonnett, the victim, who tried to prevent the robbery from taking place. The struggle left Matthew with 5 stab wounds, which ultimately resulted in his death. This is known as the Treehouse murder, where Tucker was charged with a number of felonies, including first-degree felony murder and witness tampering. At one point, Tucker went so far as accusing the prosecution and the judge of being in cahoots and working together against him. Leading up to the trial, Tucker had different attorneys representing him, but ultimately filed a motion to represent himself, which was granted by the judge.
What did you want to say, sir?
Well, Your Honor, to be quite frank, I'm going to go ahead and file a motion to disqualify tonight. So we're going to have to consider that.
Okay. That's fine.
Okay.
You can.
That pretty much ends the conversation right here, doesn't it?
No, sir, not at all.
Because I am doing my best to make sure my witnesses are here.
Sir.
Right, but I'll tell you what, it's not exactly easy when first off, I have to go through the clerk, which they don't have to do. But not only that,
Okay, so I think you can see how she's trying to portray this, right? Uh-huh. This is totally out of context because what this was in response to was the judge had denied Tucker the ability, because remember, what this was in response to was he was denying O'Quinn's transfer notice, and he was not allowing O'Quinn to come in and testify. He was not allowing Seth LeVay to come in to certify the document being the motion to suppress. And he had just thrown out all those witnesses, and Tucker was upset about it. So he comes in and he says, I'm filing this motion. Now, what this judge fails to leave out is it's that motion that ended up kicking this judge off the case, because that is a complaint that is down now with the on the judge's that's actively going on down there. That this judge, I believe, was brought in because she's a Florida judge. She knows what she's doing here. And this is the final case she talks about. And she's picking spots here because this is her time. She's hoping to redefine Tucker's case, and she makes him look like she basically portrays him as guilty.
Mm-hmm.
And you see how she's pot shotting and picking the different spots here. But let's continue.
We did go over, and we had overlap, Your Honor. There, that is the way it is. Now, I just confirmed my witnesses. Right? Now, they want to say that Tom Walker, because they're thinking I'm going to go to, see, this is the thing. They're thinking I'm going to go.
This is inappropriate.
But no, there's been evidence that has been tampered with, and we need to figure out which ones. Tom Walker has that knowledge. I mean, that's the bottom line. I mean, I don't know which videos have been tampered with. I don't know which ones, haven't been. I don't have that list. Tom Walker does.
So first of all, when a defendant, either through themselves, if they're representing themselves, or through their attorney, wants to disqualify or recuse a judge, they have to file a motion in writing. It can't be oral like this guy's trying to do. And once that motion is filed...
All right, so let's clarify a couple things here on this. He was not filing an oral motion. He clearly stated that he was going to be filing the motion.
Yes.
He was going to be filing the motion that evening, which is what he did, and he filed it by paper. But she's trying to make it sound she is totally misrepresenting the soundbite. This is a hit job, and this lady is using her position. So Law and Crime has now taken a position against Tucker. So all of you, when choosing who you watch your trials on, choose carefully. Although obviously some places are only going to be Law and Crime. We have to, but we can certainly go about it. So, I broadcast sometimes Law and Crime stuff. I think everybody kind of does. But Law and Crime is taking a position. They've allowed her, the bully pulpit, to come in and try to redefine this case. It's completely wrong.
Everything has to stop. The proceedings have to stop until the judge rules on the motion. And there cannot be any commenting on the motion. In other words, the judge can say, well, this is a ridiculous motion, or this is unfounded. The judge, according to the law, either has to say granted or denied, legally insufficient. This guy's smart. He's trying to cause a delay in the trial by mentioning this motion to disqualify. However, an attorney would have known, I need to put it in writing if I want to stop the proceedings.
When I got arrested, because Detective Pitcher was one of the ones who talked to me when they were doing their interviews. And I remember him leading the charge, but there was a good amount of officers, and they were coming in from both sides. And I remember looking up at him, and I was like, I guess we're not talking now, are we? And he's like, no. And so they arrest me, and they take me over to the jail, right? And I'm out, and the whole time I'm kind of flipping, and I'm like, literally, like, I'm like telling them I didn't have anything to do with this, and and so I'm telling him this stuff, and somewhere along the lines I get told that it's about witness tampering, right? And I'm like, and I thought it was over Paula. I thought it was because I talked to her at McDonald's. And I was like, nobody told me I couldn't talk to her, right? But that's not what it ends up being about, and I won't testify as to what it was because I think that would Mr. Mansfield probably object to it. But at the same time, so so I'm thinking, again,
it's just like a rambling stream of consciousness.
Now I'm in jail.
Ineffective.
And they take me, and they literally. Okay, the jail has the elevator, goes up, they take me in. I remember.
I mean, does anybody care about the jail elevator?
Whatever the hell, whatever that is, or they check you in, whatever, right? But they do that, and this.
Okay, so
I want to stab this woman.
well, it's like she's taking this. She calls it a stream. Listen to his entire testimony, okay? Because this is obviously, when you listen to his entire testimony, it's absolutely fantastic. He did a great job. What she leaves out is the fact that he decided to testify with 5 minutes notice because they pulled this garbage regarding Paula and the knife. And the only way he could get this in was to testify, and he had to testify and talk about it. And then they blocked him from talking about his statement. And then they turned around and came into closing arguments and lied to the jury. She leaves all that out. And she's, again, like I said, she's a Florida judge. She was the Parkland judge. and the Parkland school shooting judge. She came to fame because of her handling of that whole case, and the Cruz case, I believe, was the defendant in that case. And this is her first episode, so we can all do her a favor and never tune into another episode of hers ever again, because what she's doing to Ty here is absolutely disgusting. I mean, it's just absolutely crazy. Well, I think they think that Lauren was his wife, Jenny, but they're now divorced. So, I mean, this is
a suitcase pinata.
this is just out. Well, it gets worse. Let's continue.
Oh,
This is, I'm not going to say I haven't been to jail before. I've been to Key West jail one other time, and it was for misdemeanors, right? Boat charges. It was nothing. I mean, I can't say it was nothing, but it was misdemeanors.
He's rambling. He's talking about jail elevators. He's not making eye contact with the jury. He's just rambling, like he's talking to a therapist or talking to his lawyer, telling the story initially. Well, these are details that the jury's probably waiting on the edge of their seats, wanting to hear what actually happened. And rather than saying, I didn't do this, he's saying, I told the detective that I didn't do this, and and I went to the jail and I went up on the elevator. Like, no, that's not how you present your testimony. Again, if a lawyer was helping him, the lawyer could interject himself or herself and say, sir, let me stop you right there. Tell the jury how this.
So let's talk about the fact that she leaves out is that he had a lawyer in the courtroom. Jerry Bellarato was in that courtroom the entire trial, but he was blocked from being able to assist him. He was not allowed to come in even though he's representing himself, he could have had someone there just like Quentin Nixon had, where he had someone in the courtroom sitting there assisting him, assisting with his questioning. I mean, this is a hit job. I want you to understand this. This is a lady who is a very well-respected member of the Florida legal community. And I don't believe it is any accident that this is the first episode of her show, and this is where she ends her show at. This is the case she takes it to, and she puts all these other incompetent people and arrogant people before her, and then she ends with Ty Tucker, and you see how she wraps it up. And she goes after the one thing that he's taking right now. He's filing complaints. We've been filing complaints against the prosecutors in the case that they're feeling heat on. And she's coming in and trying to rewrite history. Mm-hmm. And she's giving a defense to the Monroe County District Attorney's Office.
Yeah.
For it. It's unbelievable. She had to step down. Yeah, well, this is the one. Yes, it is, for hugging the prosecution. Well, we know where this judge stands. She's a goofball. I mean, this is outrageous.
Event happened. When did you make contact with the police? And then if he starts rambling, a lawyer can say again, sir, let me ask you another question, and then interject so that the situation is told in a logical manner so that the jury can follow along and know from his point of view what he believes happened or what happened. This is not an example of that.
Yeah, I went down to the station. I was there all night. You have to, again, I can't tell you how the interrogation or the interview went. I can't tell you what they told me. I can't tell you anything about that.
The prosecution should be objecting.
I object to your duck face.
Not to be able to provide you with any of that information.
Or maybe they're just letting him dig his own grave.
Okay, so I want everyone to remember that what she leaves out, if she was showing this as a complete record, they objected, took him to sidebar. This was him after he came out of sidebar and got browbeat by the judge because he was trying they already objected. And this is what the judge allowed him to do. This is where the judge tried to explain to him what to say. This is where Ty really did drop the ball in the closing arguments because he didn't understand what the judge was trying to tell him to do. Whereas a defense attorney absolutely would have. But the way she's trying to portray this is dig your own grave. Listen, this is the spot right here that if she was talking, what she should be talking about is how they took advantage of a pro se defendant by lying to a jury, violating their oath to be honest with the court, lied to the jury in their closing arguments, and then maneuvered to keep out his police statement when it definitely should have been brought in under the circumstances that they're going to use. They're going to try to use something they know to be incorrect in a closing argument, which you are not allowed to do. They are not allowed to lie to the jury. They're not allowed to knowingly lie, which is what they were doing here. She leaves all of that out.
Mm-hmm.
You know, she's unbelievable, but she's leaving out the context of what we're seeing here. Because I mean, what he should have been saying is like, you know, listen, they've said that, you know, they've inferred to you that that there's only one way I could know. Well, let me just tell you this. I was at the police station. Police many times will tell suspects things that either aren't true or are true. So it is just as likely if I'm at the police station, that's why I'm going to, you know, if it was an attorney talking to him, they would say, I'm going to leave it with you. My client was at the police station with the police hours before he sees Paula Belmont. That's it. And we leave it at that. But anyways, let's watch how she wraps this up. It is just so offensive.
Mr. Mansfield also alluded to, you know, nothing being tampered with, nothing, you know, being, you know, was it mishandled or whatever. Again, I'm not allowed to talk about that.
Judge, again, objection. There's no evidence of mishandling of evidence or tampering.
Oh.
In any event, we're going to, members of the jury, remember this is closing argument, all right? And it's based upon the evidentiary record.
What the attorneys say and what the pro se defendants say is not evidence.
Both sides, that is in the trial. Not beyond that, so Mr. Tucker can certainly make arguments pertaining to the evidence in the trial.
Okay.
In terms of rulings that the judge made, that's really not for jurors' consideration.
It's not. It's not really not. It's not.
I would just submit that.
And he should not be able to bring up in closing argument
it's again,
things that he can't tell he's been ordered not to tell the jury.
Into the trial.
Well, but in any event,
but I'll watch myself. I'll watch.
This is completely inappropriate. If a judge tells you you can't get into this, you can't explain. I assume the reason he can't get into what he told the police is probably because he invoked his right to remain silent.
You assume.
Or what the police told him. I'm assuming that at some point throughout the interview, he invoked his right to remain silent and his right to have an attorney, which means the interview stops. And at trial, the prosecution can't mention that interview because you're not allowed to comment on a defendant's right to remain silent. What he's essentially doing right here with his closing argument is telling the jury that the cops interviewed him, but he can't talk about it. To me, that opens the door so that when the prosecution gets up on rebuttal, they should be able to explain to the jury why it is that the judge ruled he can't talk about his statement. Otherwise, it's unfair and looks like the prosecution is trying to hide something. This sort of bantering back and forth and talking about things that are not relevant, like, well, they arrested me and I spent the night in jail and all this kind of stuff, while he's casually looking down at his notes and talking. Like I said, it is almost always a bad idea for a defendant to represent him or herself. But why not have somebody who's trained in the presentation of evidence and the rules of evidence and who knows how to conduct a trial be able to package up your case and present it in a way that the jury is going to understand and possibly side with you. In the end, he raised enough reasonable doubt to convince at least one juror that he was not guilty. The trial ended up in a mistrial because the jurors could not come to a unanimous decision and the judge was forced to declare a mistrial.
I accept that fact. I'm going to declare this case a mistrial. So with that, I'm going to give you a final instruction here, ladies and gentlemen.
Yes, it is.
I wish to thank you for your time and consideration of this case.
And, you know, when it's tried again, in my opinion, this guy needs to have the assistance of counsel. In my experience, I have never seen a person who represents themselves get any type of benefit. In fact, I would go so far as to say every person that I have ever encountered that has chose to represent themselves did themselves a disservice both before and after trial. Also, a person cannot claim on appeal that their own ineffectiveness in representing themselves is a reason for appeal. So while many defendants who are convicted have numerous grounds to appeal and can even complain about their own lawyer and the way their lawyer handled certain situations, a defendant who represents themselves during trial and is convicted cannot use those same arguments to say, I was ineffective. So they're assuming the risk. Okay, jury, it's your chance to give the verdict. Is the man who represents himself a fool? That's all we have on today's docket. Court is in recess. We'll see you next time. Please.
We're not giving out her Instagram information to follow her or giving her any promotion beyond the fact that, listen, guys, what you heard there was, I mean, you heard what she tried to do there, right? What she attempted to do was she went after and tried to insinuate, and this is what people will be left with. Oh, Ty invoked him, and people who didn't follow this case will be like, oh, he invoked his right to remain silent. No, he didn't. That is not why. The reason why he was talking about that is because the prosecutors lied to the jury and said that they had evidence that they had evidence that they believe, or the strongest evidence in the case was his statement to Paula, because there was no way he would ever know how Matt Bonnett's blood got on there. But it's not true, because he was clearly told in the police statement. That's why he was trying to talk about it. And the reason why his police statement couldn't come in had nothing to do with that. It had to do because it was a prior consistent statement, and it was consistent with what he had told the jury. Now, Ty stepped into that trap because they were trying to bring in the pictures of his wife, of Paula, by insinuating that his wife had bought her that trip. That was all a trap, because if Ty never took the stand, they never cross-examined him on that knife. That never gets to come in. And he might have had a not guilty, because that was something that they then got to go and make a big argument about and a big stink about and say,
they bribed a witness.
Well, not even that he bribed the witness, but it was that their big argument to them was, how did he know that Matt Bonnett's blood? But the jury never got to know that he talked to the police. So in the jury's mind, they were back there. And my understanding is, I had a conversation with someone who actually spoke to jurors in the case. My understanding is that was a big piece for the guilty voters. So it absolutely worked. So again, it is no coincidence that one of the motions you saw was they wanted to get Paula's testimony to present it, and then they were getting Ty's testimony from the last trial, which they are allowed to do because it's part of the record now, and they can present that as evidence, and they wanted to represent that moment, and it was something that they got out of them. It's not evidence though, because of course Ty's got to know how to maneuver to get to make sure that he can get in the police statement now, but he's got to, for a pro se defendant, that's a complicated legal issue that you've got to be able to bring in case law for and argue it. And the reality of the situation is pro se defendants don't fare well, because judges just aren't intimidated.
By the time we got to closing arguments, he was emotionally exhausted.
Yes,
he emotionally reacted to Mansfield. He played right into his hands.
Oh,
Mansfield
he did.
fed him and baited him, and he reacted emotionally instead of doing. And I get it.
Yep, that's 100% right.
But he was completely emotionally shattered by them. And
he was completely emotionally shattered. And
you can see it in his face. He's just so frustrated with the process and the BS and the whole lot. It just.
And
how do we this woman? How do we have a go at her?
Well, you just go into that video. It's on Law and Crime. Flood the comments of that video and just make your opinion known that it's absolute garbage. She'll see it because she's going to be looking. She's a YouTuber. She's been hired by Law and Crime to do this show. So flood it, hit the thumbs down, and go in and just call her out as not knowing what the hell she's talking about. Well, it was, and they kept taking him to sidebar. And getting them, and Mansfield upset him, and he got off his game because the most effective thing is he's in a fight for his life. The misstep that Ty made was when he actually told the jury, that's what she should have been talking about, was when he said, you don't have to, basically, you don't have to believe me. If you want to, and I'm like, what are you talking about? You need to be standing up there saying,
I'm innocent.
I'm innocent, and I'm in the unique perspective. You're not. You don't know. You can't see what happened, but I know what happened. I know where I was at, and I'm standing here staring at you, telling you I'm innocent. Now, they would have jumped up and down, but to me, who gives a shit?
It's on the record.
I mean, what? But at that point, you're fighting for your life.
You can't unring the bell.
You want to let them know, listen, I mean, what are they going to do? Do it. They were not going to do a mistrial. They didn't want that. I mean,
No,
they were going
God,
to.
you remember the judge's face when he actually had to deliver that? He won.
Oh, he hated it. He hated it. He
Mhm.
absolutely hated it.
Yep.
Oh, is that so? She did get fired then? Was that because she hugged the prosecutor? Is that what it was? I heard somebody. I didn't know the background of it. I just knew she was the Nicholas Cruz case.
Was that a Florida case? Because it has in Florida.
Yeah, that was a Florida. It was the Parkland, Florida school shooting, and yeah,
She needs to lay off
she
the
messed the
Botox
case.
and the
I
fillers.
know. I didn't. I really, to be honest with you, I did not follow that case too closely.
Yeah.
I mean, I have an interest now following it just to point out all the mistakes she made because she's. We're
Can
gonna
we
do
do that?
we'll do a whole 3-hour show on
We need a
her and just
reaction video.
absolutely just
A reaction,
react to her judgeship and just go over all
Yes.
the.
Can we do a react to her?
We will short her out and just absolutely point out all of her unethical and terrible
Yes.
behavior. Yeah,
Can we do
will
a stream on
absolutely.
that?
Yeah, for certain. We need to go back and break it down.
Yep. For shiz.
Oh, so you just said she lost with the defense and the guy mentioned her kids. Oh, okay. So she says, yeah, she got fired. The penalty phase and showing bias. Wow. So that's where we're at. So, you know, just so everybody understands where the case is at on the 26th of this month, as of right now, there was some talk at the end of that where they were clearly this week, there is no case being set right now. My understanding is the 26th is when it's happening. The judge ended up having trials. So it's going to happen on the 26th. It'll be at 4:00. You know, so Christine Fortunato says, Ty said to me he still needs help for sure. Absolutely. We'll share with us, Christine, what do you mean?
So, do we know what time on the 26th?
It'll be at 3:30. It'll be at 3:30 in the afternoon. Now the thing is, there's no way to live stream that stream because you can't get sound. So I'm going to have to record it if I can get into it again, and then it'll be streamed later that night. No, this hearing will not be streamed flash. I have to go in and I'll have to record it again like I did, but you can't stream it with sound. You would just get a visual. And it would just be too much of a mess to try to even produce that. Now, if I think, I don't know, I have to look into it deeper, I think, but at least that day it wasn't working for me to get the streaming software because I was trying to actually capture it on my streaming software in hopes that, you know, I wasn't sure what was going to be going down, but I was hoping to be able to capture it and then be able to very easily set up a live stream.
No, Judge Morgan, the first thing he did was cut all media because he doesn't want Ty's case to be heard. He doesn't want anyone to know what's going on. That's the whole reason they put him in jail.
That's exactly right. That's exactly right.
Why would he televise it? That's the
now
whole
under your
problem.
scar says, when do we hear Ty's feel? What is that now? What is that? Feel?
Well, hopefully he'll reach out on the 26th when he gets out because I'm thinking positive.
Yeah, I mean, my thought is that there will be, you know, my understanding is Ty's going to probably, you know, he's going to focus on seeing his family and lay low. Yeah. Oh, when will we know Ty's deal? On the 26th. Unfortunately, right now, there's no way to get the specifics of that deal out. You know, so it's just, you know, unfortunately, there's just no way to do that. Oh, yes, under your stars, I did. In fact, I had gone into a stream you were in. I don't know if you saw it. I had thanked you for it and said thank you for that. But I think you may have already been out of the stream when I went in, and it just got pushed up. But yes, I did. Thank you. Thank you under your scars. I very much appreciate that. Thank you.
Have you got a channel under your scars? She got a YouTube channel?
I don't know. Let's see here. Let me go in and see if she does. We'll find out. I can click in.
And Christine, I'm on different software. I don't know how to work all that stuff, so will have to be another time, Dylan.
Yeah, I mean,
we had trouble setting it up, and Steve had no power about half an hour before we went live.
Oh yeah, we had a bad thunderstorm. I wasn't able to. Oh God, yeah, it was a mess. But that's where we stand. So it looks like we're going to have a resolution unless something falls apart greatly. You guys heard it. I mean, you heard it out of the. That's why I felt comfortable bringing this out. There's a lot of things we can't talk about right now, but it'll all become clear, I think, once we get to the 26th. You know, I believe, I don't know for certain, but I believe it'll be an Alfred plea. I can't imagine Ty doing anything other. Whatever he's going to be pleading to, it's going to be it's going to be his ability to maintain his innocence, but work this out, which is, listen, I don't blame him. I don't think anybody should blame him. It's the right move to get out of jail, and then he can start fighting the other end of this fight, which he's going to need everybody. I mean, he's going to need everybody's support, because it's then that he's going to be able to, it's going to be up to us to try to continue to bring attention to the case. Let him come and talk. Let us continue to really do some good work here of exposing what he went through. Because
now you put the link to the DOJ in the description, didn't you? Like, are we all?
I had it in one of my previous ones. I don't know if it carried over in this one.
Do we still need to be doing that?
Oh, absolutely. I mean, put in the DOJ, the complaints to the. I mean, listen, we need to be trying to get now. Again, when he gets out and he has the Alfred plea, hopefully he'll be in a position to then work with them, to have them go look at the different facts and circumstances that were going on down there in this case. But most importantly, listen, civil cases get a very bad rep, right? But what my dad used to say is there's one reason why you do a civil case. This is why people file civil cases. This is why, people in general would use a civil case, because it's the right. You can file a civil case with very little. You just have to have a very small, assertion that what you have is true. Because unlike a criminal case, the civil case discovery process involves investigative powers. So it basically allows, let's just say I wanted to file a suit against my neighbor, but I had a statement that says, hey, they came over and bashed my window in my car, but I need the ability to call them and put them under oath. I need the ability to go subpoena their alarm company to get records. I can't do that as a private citizen, but as soon as I file a lawsuit, I have subpoena power. If I can show the court that there is a probable cause to do so, and I can say, hey, I'm going to go, I need this, and I can bring them in. I can bring them in and force them to answer interrogatories. You can do all of these things. Ty is going to get the ability to do that. He has attorneys that are sitting and waiting. So when he resolves this case, and if he's able to resolve it with an Alfred plea, he's going to be able to begin that part where he's going to be able to put people back under oath, just like he did previously, where he put Pitcher under oath, and we know what came out of that. We know there's bad things that happen.
Absolutely.
Tracy Mudgeway, I can certainly try. I have not tried to do that, but I certainly can try to do that. I'm sure it's out there, because I think it was publicized when it happened, but I could certainly try. But yeah, so I mean, it's a situation where this is just the start of the fight. So I think that everybody's just got to make sure they understand that, and that I don't think risking your life in a trial with corrupt individuals is the smartest move. I think you got to, when you're going against corruption, you've got to go about it as a chess match. You don't go directly in. You don't go punch the guy with all the power directly in the face and give him a response, and you're within proximity to get a punch back. You figure out a way to take his legs out, take his arms out, tie him up, and then you start punching.
Pummel the crap out of him.
And then you pummel the shit out of him. And that's what Ty Tucker's doing right now.
Yeah.
Absolutely, yes, under your scars. You can. That's the magic of an Alfred plea. He's not.
That's why it's different.
From the court perspective, he's not factually guilty. So he can keep the fight on. because he's not. That's the difference between a no contest plea and an Alfred plea. No, well. Now, Flash fan, he has civil lawyers that are waiting, but they have not been able to go forward because they have to wait for the criminal case to get worked out. If he works it out with an Alfred plea, he's going to be able to pursue that. Not to mention that there are other things going on in the media that are waiting to be released for this criminal case that's going to hopefully bring great attention to the case. Some things I've been involved in behind the scenes that I know about that are going on that are going to hit the media, that are going to hit podcasts and things of that nature that are waiting. They can't be completed until this criminal case is done. Mm-hmm. And this is when we're going to get it out. This story is going to get told in a big fashion.
Yep.
And it's going to get told in a way that all of a sudden, this conversation that we have that has like 20 or 30 people in it, it's going to have thousands of people that are going to be interested in it, because it's going to be like remember the making of a Red Rummer. That guy was actually guilty. This is a guy that's innocent. Mm-hmm. So when this hits and people start looking into it, it's going to be huge. So rest assured, this is a great way to do it. This is the way it needs to go. And this is a chess move, right?
Yep.
This is a chess move.
He's not playing. One, I think.
Going to trial, taking on Big Bubba is checkers. And with the guys that he's got and Morgan there, this is a good move. And given the fact that he's already got a mistrial, he's got a hung jury under his belt, that judge didn't like that. That's a victory. He beat these guys once. Yep. But listen, you don't go under the conditions he's in right now. Locked up. They've got him hog-tied, and they're bringing him into the courtroom, unable to fight. So I know who they are, but I'm not going to put that out there at this point, because that's not information that I need. Ty will tell you all of that when he gets out.
Yes, when he gets out.
When
26.
That's exactly right. And
how many sleeps is that?
He'll be absolutely. How many sleeps? What are we at?
5, is it?
Yeah, it's six sleeps. Yeah, he's got in jail. 5 sleep. Well, 5 for you, Jody. It's 27 for you. It's 27.
I got the Leilani Simon sentencing date wrong.
Yeah,
I was a day early.
Oh gosh, yeah, because I have the whole date.
Yeah. Goddamn time difference.
So yeah, he very well could be. Yeah, he could be. Yes. Yes.
I hope so. I really, really hope so. I'm thinking positive. I think this is the best outcome for him, and I think it's gonna, it'll be.
Yeah, because it'll be Tuesday. Yeah, because Thanksgiving. Yep, he should be out and eating turkey and get in, and hopefully with some family and getting things done. So I mean that's what we gotta hope for, at least. So like I said, it's a good positive thing. We're moving in the direction we need to move in. This thing is going to be a good thing for Ty. So
absolutely.
I hope everybody is ready to celebrate when it happens, and we'll be ready to celebrate. And hopefully he'll come on and we'll talk, and we'll be able to really chat it out and talk it out and get into stuff. Yes, he does. And his son, listen, you got to remember, guys, Ty Tucker was out on bond, but he was not free. Ty Tucker has not walked free. He's not gone into a restaurant. He's not gone shopping. He's not done any of those things since 2017.
Yep.
Now, he did get a little touch of freedom in January because he was down there and able to walk around, and the judge lifted all that. But that was like, he was in the middle of trial. So how enjoyable was that?
Yeah.
I mean, he was just going back to his hotel room and preparing and jumping all over the island. But he's sweet potato pie when he eats that. Absolutely. Hey, sweet potato pie, pumpkin pie, all of it, man. Have yourself a feast.
Yeah.
In fact, that day I'll be celebrating Thanksgiving on that day, because that's when my family and I are going to be. So I just realized that. So I guess we'll be suspending the celebration about 4:00. I'm going to have to plan around that. But yeah, it's going to be a big deal. It's going to be a fun deal. It's going to be a big deal. It's going to be a really good, amazing, fantastic thing. So I hope everybody feels that way. You should feel that way.
So how do you reckon, how long before we find out on the 26th, do you think your contact down there will let us
Oh,
know.
I'll know. I'm hoping I'll be there watching live. So I'm hoping we'll know. If not, we're going to know. It'll be updated on the Monroe County docket. I'm sure I'll be reached. Yeah, listen, it's going to be going down. My contact, I think, is going to possibly even be coming down to meet with him at some point. So I don't know. He might even, be in the States then, be down there. It's going to be.
We can have a Justice Watch party.
That's
from
exactly.
3:30.
Yeah. Yeah. Well, and that's what I mean. I can be, even though I can be sitting there watching it, videotaping. I have my iPad there. Maybe I can put a camera on it. We could try to figure out what we can do there. But if I get, again, I'll try to figure it out.
Anybody can get it. Yep. Just keep next Thursday free. Okay.
Well, even if it's just sitting there and updating the Monroe County Clerk's Office website,
I can do that.
It's going to keep, it's going to be updating there, so it'll be a big moment. Be a big moment for Ty, big moment for everybody. So, that's where we stand on that. So, well, Jody, is there anything else you can think of on this subject matter? I'm losing my voice here. For all of you who have been wondering, I didn't really do my normal end of. I wasn't talking at the end of my lives with the very important case because I've been sick. I've had the flu. So if I'm looking a little run down, that's because my cough medicine's wearing off and I'm about to collapse. But it is
So podcast Saturday, 9 a.m.
Podcast Saturday. Yep. And we're going to be talking Colt baby case. We're going to be talking Chloe Driver. So it's going to be a fun one. We're going to have some fun with that. And we're going to be talking about all the things I should have been talking about this week. I did get a little talking in, but not
a Steve talk.
Not normally. I just don't feel the So hopefully I got a couple days to get my energy levels up and be ready to rock. So
And I've done a bit of a deep dive on urology, urine therapy as well.
Oh, well, yeah, I know. Everybody have listen, we're going to do a little, we're going to do a little trial of that. So everybody come with a cup of urine on Saturday.
A pina colada.
Yeah. Yeah. So, but, yep. So anyways,
everyone share this video.
Yes, share this video. Thank you, Sarah. Appreciate that. Yes, like I said, that's why I was running the last of those trials. I was keeping them up, and I was laying in bed at times and just trying to manage. But it was, I'll tell you, it's been a tough one. The whole family's been down. All my kids have been out. It's just run right to us. So unfortunately, my sister came into town and brought it to us, and it just kind of went all the way through. So,
yes, please.
Oh, absolutely, Christine, for certain. Please. Yeah, for certain. Yes, absolutely. Yep. So, anyways, with that said, guys, I think we got. I think we're gonna end this thing. So, spillers to spill pea drinkers. Yeah, absolutely.
We had a bit of fun with that.
Hey, maybe you know what? Maybe urine therapy would be helpful for the flu.
No, it's not.
No, it's not. Oh, it is.
I've looked into it. Trust me, it's not.
Okay.
I'll fill you in on Saturday.
All right.
What is it? Drinking thine own waters from thine own cistern. Yeah.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice unite.